Is Shark Tank just one big scam? I mean, we've heard some success stories like Scrub Daddies and Squatty Potties, but could those be the exceptions and not the rule? I know you're used to me covering crypto scam after crypto scam after crypto scam, but I have range, I have variety. I can also cover regular schmegular scams. But first, we have to find out if that's what actually went down in this situation. So join me, America's attorney, in breaking down former Cleveland Brown player Al Bubba Baker's claims that Shark Tank superstar Daymond John scammed him out of millions and the consequences of those statements. And if you like the video at any point, then I am ready to offer you 100% viewing satisfaction for the 5 to 10% effort of hitting that subscribe button. Who's ready to invest? Let's start from the beginning. Al Baker and his daughter appeared on Shark Tank in 2013 to present their boneless baby back ribs, a patented process that removed the bones from rib meat. Daymond John agreed to invest $300,000 in exchange for 30% of the company. But once the camera stopped rolling, this was changed to $100,000 for 35% of the company. The two parties continued to work together for years, but the relationship began to sour, with their demise culminating with a business relationship between the Bakers, Daymond John, and Restraining Foods Group. The establishment of this relationship seems to be the moment that the Titanic hits the iceberg, but for more details about what led to the crash and the sinking of the duo's professional relationship, check out Scott Schaefer's breakdown. So what exactly happened that caused Al Baker to distrust his special shark? An investigative article in the Los Angeles Times revealed that the creators of the boneless baby back ribs were left out of key meetings, and their once proportionate cuts of the revenue quickly dropped to scraps. Multiple sources claim that from the $16 million that the company made during its time with Daymond John, the Baker family only received about $600,000. The family also stated that they believed that there were fraudulent and illegal activities in the accounting practices between Restraining Foods and Daymond John, and that they felt that the need to go public with these allegations was so serious due to a lack of communication between the three parties. Now, a very important note in the timeline of events is that in 2019, the Bakers and Daymond John settled their dispute. This means a legal agreement was signed that probably held terms like full mutual releases and confidentiality and non-disparagement. A one-sided release is an agreement whereby one party cannot sue the other, but mutual releases mean that neither party can sue the other forever, and it's the end of the dispute. And their agreement also contained a confidentiality/non-disparagement agreement that prevented both parties from speaking about the agreement and kept them from saying anything bad or disdainful about each other on social media or to the news. Daymond John not only denied all the allegations in the lawsuit and their subsequent claims, but he filed a lawsuit himself asking for a restraining order against the family for violating the terms of the 2019 settlement agreement. Before I get into the restraining order, let me say that if they own roughly a third of the business and they got 4% of the revenues as profit, then that implies that the business was running at about a 12% profit margin, which is not too shabby for a business that's youngish and in growth mode. Evidence for the restraining order was easy to collect, seeing as the family had been very public, speaking out about the nightmare experience that they said that they had working with Daymond John through news articles, news interviews, and social media posts. John also testified that the Bakers' public rants had caused him irreparable damage in the form of a canceled TV show with a major television network, a lost speaking engagement, something that he was normally paid over $50,000 for, just like me, and the loss of an opportunity with a major brand. Now, as we all know, this restraining order was approved by the judge, and the Baker family was ordered to zip their mouths shut about the Shark Tank star and remove all defamatory posts that had already been made. Now, if you're like me, you heard of restraining orders to deal with threats of violence or actual violence between family members or people who are romantically involved. And while tender, juicy ribs make me feel a certain kind of way, it doesn't mean that the business owners were romantically involved, that one could get a restraining order against the other. But if you agree in writing, aka a contract, that you won't speak negatively about someone, and then you start speaking negatively about them, well then that's a layup for the plaintiff's attorney and it's a slam dunk for the judge. Because the whole notion of agreeing to keep your lips zipped is premised on the idea that unzipped lips, can do financial damage or other irreparable damage to the other party. And you can't really defend against a requested restraining order by saying,
hey, I wasn't even saying anything bad.
Because then you're at least tacitly agreeing that you shouldn't be talking badly about the person that you're talking about. And in fact, the only real defense to a claim like this is to say that the agreement that purported to bind you to silence is not valid. It's not an enforceable agreement. But obviously, the judge said,
no, man, that's the real deal.
So he bound the Bakers to silence forever. What you might be thinking is like, wait, what about the First Amendment? Can't people say what they want to say? Well, not exactly. The muzzle, the lack of free speech, this is not a right that you cannot contract away. In fact, you very much can sell your silence, and people do this all the time. This is just a classic non-disclosure agreement. And that's the thing. If the Bakers were paid an agreed sum of money to not talk about a supposed scam or even a real dispute or something really bad or whatever you want to call it that they had with Damon John, then the money can buy silence. Now, as you know, money can't buy love, but it can buy the absence of hate. And if you get paid some money to shut up, that is an agreement that is not impaired by the First Amendment. So Damon John got a permanent restraining order. Now, does that mean that he didn't scam the Bakers? Of course not. It doesn't prove that at all. In fact, practically speaking, to me, to an outsider to that situation, but someone well-versed in lawsuits, the fact that John paid the Bakers settlement money, to me, that means he probably did mistreat them in some way. Now, maybe he didn't, but again, that doesn't mean that they can now talk bad about him, because if he said that he'd pay them for, at least in part, silence, then they just got to shut it up. And that's not just my opinion. Obviously, the judge agreed. But do you? Damon John may have won in the judicial system. Well, what about in the court of public opinion? Were the Bakers right to break their settlement agreement so that the truth could be exposed? Let me know what you think by dropping your pro se opinion in the comments below. Just slather the comment section with your opinion. And if you enjoyed my content about this regular scam, check out my breakdown of these crypto scams right here. And I will be back with more videos so soon. What? I'll be back with more videos soon. So hit the subscribe button. See you, bye.